Now, I've been receiving a lot of questions on this opting out procedure, and we've had some conversations on it. Tell me a little bit about why an association may want to opt out and how it would actually work if they chose to opt out.
The way the statute was set up, and I was one of the principal drafters in '08 on this, is what I call a three-tier system. The first tier is what is the insuring obligation of the association, and the statute lays it out. There is an issue on whether owners' add-ons outside are insured by the association. I can cover that separately. So that's tier one, the insuring obligation. If you insure it, you go down to tier two, and the association makes the repair. The third tier is who shares in the obligation and the costs. The general rule is everybody shares in the cost unless you opt out of the allocation that is the sharing. You cannot opt out of what you insure. You cannot opt out as to what you have to repair, but the association could choose to opt out of who shares the loss. And Hurricane Irma laid this question out because a lot of compressors located on the roof or outside the building toppled.
Yeah.
And that is an association insuring obligation. Therefore, the association insures, and therefore everybody in the condominium shares in the cost. So if there's one AC unit that topples, needs to be replaced, everyone pays toward that cost. If the association believes, you know what, we don't really like that, we want to say that we're going to back charge the owner whose compressor was damaged, so that owner exclusively shares in the loss. That's what opting out is all about. It's not amending documents. It's a separate vote taken. It's a majority of all owners in the condominium. You don't have to just opt out of the HVAC system. Some may choose to opt out of drywall. Because a lot of times, not a pervasive event like a hurricane, but you have a pipe break, and usually maybe one or two units and no others are impacted, but everyone has to share in that loss. So would it be more equitable, according to the membership, to take those type of items and allocate them to the owner who had the damage, so everyone else in the condominium ultimately would not bear that expense?
You can't just add an HVAC to a unit owner policy, unit owner HO6 policy.
Unless you can get an endorsement, but I don't see how you would get one because it's always in the master column. Where the debate would be is where an owner, let's say, enclose a patio and put an expensive screen enclosure or even a glass enclosure, and that gets damaged. My interpretation of the law, and this is going to come to a head pretty soon, I think, is that when you insure other than the original construction and like replacements, there's also a second category that you have to insure for material alterations to the property. And the insurance section throws you to the material alteration section in 718. That 718 material alteration section is not limited to just association-made alterations. It's any, including owners. So in my opinion, the association must insure for these add-ons, must repair those add-ons. But there's a unique language in the add-on section, is paragraph N. And that says the association shall not pay for, which is a little different than some language used elsewhere, shall not be responsible for the cost. If you don't pay for, no money comes out of pocket. So in that case, even though you have the obligation to repair, to the extent that there is no insurance or a shortfall, the difference has to be put in by the owner so the association doesn't incur an outlay.